When is the authorized capital stock bonded? Indebtedness considered as increased, incurred, decreased. The authorized capital stock bonded indebtedness shall be considered increased or decreased incurred upon approval by SEC and issuance by the SEC of its certificate of filing. What is preemptive right? Preemptive right is the right of shareholders to subscribe to all issues or dispositions of shares of any class in proportion to their respective shareholdings. When is preemptive right not available? DCG. As a rule, all stockholders of a stock corporation may enjoy such preemptive right. However, preemptive right is not available in the following instances: when denied in the Articles of Incorporation, when shares are issued in compliance with laws requiring stock offerings or minimum stock ownership by the public, and when shares are issued in good faith with the approval of shareholders representing two-thirds of the outstanding capital stock in exchange for property needed for corporate purposes or in payment of previously contracted debt. What are the requirements in order for a corporation to sell or dispose its corporate assets? The following are the requirements to sell or dispose the corporate assets. As a general rule, the majority vote of the board shall only be required if the sale or disposition does not cover all or substantially all of the assets. However, if it involves all or substantially all of the corporate assets, including its goodwill, the following shall be required: majority vote of the board, assent of stockholders representing at least two-thirds of the outstanding capital stock or two-thirds of members in a non-stock corporation, and meeting duly called for the purpose. And in case of non-stock corporations where there are no members with voting rights, the vote of the majority of the trustees in office will be sufficient authorization for the corporation to enter into any transaction authorized by Section 39. When is the authorization of the stockholders not required even if there is sale or disposal of all or substantially all of its assets? The authorization by the stockholders or members is not required to sell, lease, exchange, mortgage, pledge, or otherwise dispose of any of its property and assets in the following cases: if the proceeds of the sale or other disposition of such property and assets be appropriated for the conduct of the remaining business. Under what circumstance does a sale or disposition qualify as a sale of all or substantially all of the corporation's properties and assets? A sale or other disposition shall be deemed to cover substantially all the corporate property and assets if the corporation would be rendered incapable of continuing the business or accomplishing the purpose for which it was incorporated. What does the Nell Doctrine provide? Under the Nell Doctrine, the sale or transfer of the assets of one corporation to another does not ipso facto include the debts and liabilities of the transferor. What are the exceptions to the Nell Doctrine? The following are the instances where the Nell Doctrine does not apply: where the purchaser expressly or impliedly agrees to assume such debts of the transferee, where the transaction amounts to a consolidation or merger of the corporations, where the purchasing corporation is merely a continuation of the selling corporation, where the transaction is entered into fraudulently in order to escape liability for such debts. When may a corporation abandon a sale or disposition? The board of directors or trustees may, in its discretion, abandon the sale, lease, exchange, mortgage, pledge, or other disposition of property and assets subject to the rights of third parties under any contract relating thereto, without further action or approval by the stockholders or members. What are the conditions before a corporation can acquire its own shares? Corporation can acquire its own shares provided The acquisition must be for legitimate purpose or purposes such as the following: to eliminate fractional shares arising out of stock dividends, to collect or compromise an indebtedness to the corporation arising out of unpaid subscription in a delinquency sale, and to purchase delinquent shares sold during the said sale, to pay dissenting or withdrawing stockholders entitled to payment for their shares under the provisions of this code, to acquire treasury shares to effect a decrease in capital stock, to purchase or take up redeemable shares, and when the SEC orders a closed corporation to purchase the shares of stockholders in case of deadlock in its management. The corporation must have unrestricted retained earnings to cover the purchase of the shares, except if the purpose for Section 8 or Section 103 Republic Planters Back versus Agana, Senior GR number 51765, March 3, 1997. What are the instances when the corporation can acquire its own shares even when there are no available unrestricted retained earnings? The corporation can acquire its own shares even when there are no available unrestricted retained earnings in the following cases: redemption of redeemable shares, when the shares are reacquired by a closed corporation in case of deadlock. What are funds?